This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today, we're going to talk about water damage and how a plaintiff's expert established lack of coverage for the plaintiff in a claim against their insurer for water damage, and why it is essential that a court, when seeking to interpret a policy of insurance, must read the full policy to determine the coverages applicable. Plaintiffs Joshua and Rachel Dow purchased their home in Hurricane, West Virginia in March of 2018. The property is contiguous to the Valley Park wave pool. After plaintiff purchased the home, they entered into a contract for first-party insurance with Liberty Insurance Company, and as of June 2018, plaintiffs noticed water entering their property and leaking into the crawl space of their home. In Joshua and Rachel Dow versus Liberty Insurance, a December 1, 2022 decision of the United States District Court for the Southern District of West Virginia, the plaintiffs sued their insurer who had refused to pay their claim, and the district court dealt with the issue of coverage for damage caused by the water entering their property. The water had flowed from the edge of a ditch on an adjoining property into their yard. This ditch ended 2,030 feet from the plaintiff's property and had carried water downhill toward the river for several years, even before the nearby wave park was built. For many years, this ditch carried water without damaging plaintiff's home. However, the Putnam County Commission built a maintenance building on the property at the wave park in 2018, which raised the elevation of the land. Construction on the maintenance building ended in March of 2018. Because of the elevation change, heavy rain and water problems at the wave park overwhelmed the ditch and forced water into plaintiff's yard, which entered the crawl space of their home. Liberty's claim specialist was advised that the county was in litigation over the matter and would not discuss anything with the insurer. The defendant insurer formally denied the claim on November 28, 2018, asserting that the claim was denied because water had traveled through the ground, which was excluded under the policy. The insurer attached a full copy of plaintiff's policy to their motion to dismiss. The full policy excluded, quote, flood, surface water, waves, tidal water, overflow of a body of water, or spray from any of these, whether or not driven by wind, and 2, release of water held by a dam, levee, dike, or by water or flood control device or structure, and B, water below the surface of the ground, including water which exerts pressure on or seeps or leaks through a building, sidewalk, driveway, foundation, swimming pool, or other structure, close quote. Plaintiff sued. An engineering expert retained by the plaintiffs opined that the topography as it currently lays forces and directs the water course onto the plaintiff's property and into the crawl space of the plaintiff's home. Inherent in the interpretation of the claims, according to the district court, is the issue of whether the damage sustained by plaintiffs is covered by the terms of the policy. When a policyholder shows that a loss occurred while an insurance policy was in force, an insurance company seeking to avoid liability through the operation of an exclusion has the burden of proving the facts necessary to the operation of the exclusion. The insurer must also prove that the alleged applicable exclusion is valid, unambiguous, and substantiated. Defendants specifically identified additional exclusions that would further limit the number of cognizable water damage claims when it applied for approval to the Department of Insurance of the state of West Virginia. Further, there already existed a broad exclusion for water damage in the base policy, demonstrating that the defendant's intent to widely exclude coverage for water damage in its insurance policies. Although the defendant omitted the particular phrase, quote, water control device or structure, close quote, from its summary finding, it is essentially synonymous with the specifically stated sources of water damage, such as dam, levee, and dike. The court concluded that the exclusion utilized by the defendant to preclude coverage for the water damage to the plaintiff's home was therefore valid. A court interpreting an insurance policy must also give the language of the policy its plain and ordinary meaning. Where the words of the policy are clear and unambiguous, it is not the role of a court to judiciously construct or interpret meaning, but rather give full effect to the plain meaning intended. It was clear to the court that the plain, ordinary meaning of the words leaves the meaning of the exclusionary policy language clear. First, the reference to a water device or structure must be read in connection with the other specific terms in the exclusion, like dam, levee, and dike. Standing alone, the phrase water control device or structure might be ambiguous, but the court must read the phrase in the context of the entire exclusionary provision, including the underlying base policy's water damage exclusion. Since plaintiff's expert described the water damage to plaintiff's home as resulting from water flowing from upland of plaintiff's property, through a channel that was designed to capture water on the hillside and control it. The purpose of its creation was to gather the water into the watercourse to stop it from inundating the surrounding properties. It was clear to the district court, therefore, that the watercourse described by plaintiff's expert is a water control device or structure. The water causing the damage was external to plaintiff's property. It was channeled and controlled, and ultimately it was released from the watercourse and damaged plaintiff's property. The fact that it is plaintiff's expert testimony that supports the exclusion of coverage has no bearing on the application of that testimony to the analysis of a summary judgment motion. The court can and properly does consider plaintiff's expert testimony, and the expert testimony supports the exclusion of coverage. The court was sympathetic to plaintiffs and the hardships they've experienced due to the damage to their property. Unfortunately for the plaintiffs, coverage for these water damages was not afforded under their insurance policy. In my opinion, RTFP, read the full policy, is the key to the interpretation of an insurance contract. The court did so and applied the full policy, and its meaning was clear when read in its entirety. The case established that it is improper for a plaintiff to try to change the meaning of a policy by taking a part of that policy out of context and away from the rest of the policy wording. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link on the URL zalma.com/blog, where you can read this blog posting and more than 44 other blog postings. So you might want to subscribe to receive what will be at least 5 blog postings a week. And it would also be interesting to subscribe to the videos at rumble.com, where there's more than 550 videos, or youtube.com, where there's even more videos on insurance and insurance coverage matters. Subscribing to the blog postings and the videos would be very useful so that you miss nothing of importance. If you found this video and the blog posting to be of interest and useful to you, Please tell your colleagues and friends so that they can also subscribe to the blog and the videos. Thank you for your attention.